said I was a footnote, background noise, a misfit, unimportant, too loud. Funny how that turned to kismet. Me and my truth, we sit real still, no sirens, let them scream in the daylight. Truth don't need alignment. I didn't want the headline, I saw the pattern. Opening my mouth made the whole room shatter. Try to keep it measured, flashing warning signs. Every time I spoke the truth, they called it crossing lines. I stayed out of the spotlight, studied every thread. Watched the story bend while they counted what I said. Never chased the platform, never begged the crowd. I was mapping all the quiet while they weaponized the loud. Not a drunk, but you can call me boozy. There's a lot more here than simple beauty. It's my time, I'm showing you the real me. Formally introducing Boozy Beauty. Boozy Beauty. Boozy Beauty. Boozy Beauty. Daily in the gym, yeah, I build this body, but don't confuse the muscle with the mind inside me. Got the ladies watching when I teach that beauty, but the real flex is know exactly who I'm proving. It's deeper than looks, deeper than likes. I'm sharpening language, intellect precise, full play, firm lines, boundaries set. I light my soul up, I don't need their respect. While they were boxed in my dark, clean, bold lies, I was face down, boxed in, hit from all sides. If they look beneath the noise, they see I never wanted fame, just wanted pat on scene. Not a drunk, but you can call me boozy. There's a lot more here than simple beauty. It's my time, I'm showing you the real me. Formally introducing Boozy Beauty. Boozy Beauty. Boozy Beauty. Boozy Beauty. Snakes in the grass slithering in my phone. I walked out clean when the silence hit home. Diamond in the rough, no filter, no scene. Funny how the dirtiest hands claim pristine. Not a drunk, but you can call me boozy. There's a lot more here than simple beauty. It's my time, I'm showing you the real me. Formally introducing Boozy Beauty. Boozy Beauty. Boozy Beauty. Boozy Beauty. You can call me boozy. Raising back on rising beauty. I've been here, now you finally see. Say it right, Boozy Beauty. Boozy Beauty. Boozy Beauty. Boozy Beauty. Boozy Beauty.
Hi, everyone. Hello. Running around today, as you all can imagine. Hello, everyone. It's crazy. All right. If you are new to me, hello. I go by the username Boozy Beauty, and I am from Norfolk County. And I think that's all I need to say about that. Well, today we had yet another Karen Reed hearing, and can we all guess how it went? Not as expected. So, in particular, or should I say in specific, this is for the O'Keefe family estate versus Karen Reed / the Canton Bars civil lawsuit. And as we all know, it seems like nothing that ever is in the realm of these hearings ever goes to plan. Ever. I want to thank you all for being here, whether you are chatting live or you are part of the replay crew. Just all know I appreciate any of you that are here spending your time with me. I really do appreciate it. Let me just say this. There's a lot of rumors going on right now, internet fodder. We're all trying to figure out exactly what's going on. So what I plan on doing is this is what I like to do. I like to bring a little woosah, calm us down a little bit. We'll talk through it, go through the various filings, what do we know, what we can maybe guesstimate, and then hopefully come to some kind of conclusion. Because when I say I walked out of that courtroom even more confused than when I walked in. That is saying it kindly. I was expecting some attorney arguments, and it was just basically Judge Gildea did a speech and then said bye. So we'll get into everything. If you're brand new to the case, don't worry. If you're brand new to anything that happened to this hearing, everything is going to be broken down so that at least we can walk away with a little bit more knowledge, hopefully, because we need to talk through this together, chat. I'm going to say hi to chat for a second, and then we'll get going. Replay crew, feel free to fast forward, or you can just hang out. Just hang out. Also, mic check. Is this thing on? What a day, guys. What a day. I crazy. Hi, Krista. Hi, Carrie. Wow. What a day. Hi, Casually Kiki. You waited all this day for this live. Oh my God. Thanks for being here. Hi, Sherry. Oh boy. What is Emily already saying? I'm convinced Gildea said, "Oh, you guys want to try this case on social media? Here's an impossible puzzle for you internet sleuths." No, legit though. Like actually. No, literally. Hi, Brandy. Long time no see. Hi, JC. Hi. Oh my God, that is the cutest puppy ever. Hello. Welcome in. Hi, Johnny Lunch Bucket. What a funny name. Love you back. Hey, Jinxie. Hi, Cassandra. Oh my God. Yes. And thank you to my mod. You guys are amazing. Hi, Bob. Cassandra. Jen. Siding at the sidebar. This is so much fun. You guys are amazing. Okay. No, Susan. Can the X post be for you? No. We'll get into it. Trust me. We'll get into more of it a little bit later. We'll try to break it down as much as I can. Hi, Colleen. Hi, Lady Wags. Hi, Big Old Dog. I love seeing so many familiar names in chat. Like, this is freaking incredible. I tell you guys all the time how just ecstatic that you guys are all here spending a little bit of time with me. And hello, backseat juror. Okay. Well, it's this whole thing is about Proctor. It's like you can't make it up. Okay. So this was another unexpected emergency hearing that was put forth by Judge Gildea last, what was it, Monday? 2 days ago. Today's Wednesday. And I think every single one of us, and we can only assume that the lot of attorneys were kind of like WTF too, because this filing, this emergency hearing was supposed to be in person. Like literally he said everyone needs to show in person. And it's like, okay, there's a lot that has to go into this. A lot that goes into this. So brief rundown regarding exactly what the hearing is about. Something along the lines that something leaked regarding Michael Proctor's deposition. And once we get into the hearing, you'll hear Judge Gildea and what he says like went down when it came to something that he had received. So a couple of weeks ago, we'll say earlier in June, Michael Proctor was set for a deposition. They set for an immediate emergency hearing because he didn't want to be deposed anymore. As you all probably know, that didn't go in his way. We had an early morning, Monday morning hearing where Judge Gildea gave Proctor and his team an opportunity to put in more files, give me more proof or more evidence of what exactly is going on and the reason why you cannot sit for this deposition. That is allegedly was leaked, but the hearing, what was it, 3 hours ago that this hearing had ended. I've spoken to a host of people. I have watched a little bit of Melanie Little, a little bit of Lawyer You Know, a little bit of Defense Diaries, and everyone is in the same boat because we have no clarity, unfortunately. It just seems like without Judge Gildea telling us exactly what he received, it made no sense in essence. So the filing, let me put myself over, is this guy right here. So something in regards to the endorsement on paper number 112. Thank you, obviously, to Kyle Sharkey and DD Suspicious Sauce for clearing this up because there was even more rumors over the couple of days that we've had to think about this. And paper 112, like I said, is something to do regarding Michael Proctor's deposition. The affidavit, or maybe his doctor health notes, something. We thought we were going to get answers to this chat. we thought wrong. And then this was filed. Basically, everyone needs to show up. No ifs, ands, or buts. And you also need to make sure you all, under pains, penalty, and perjury, you tell me exactly who you spoke to regarding this impounded paperwork. Impounding is just another fancy word for sealed. These documents that should not be seen the light of day. And guess what? Oh, did the attorneys do that? And can I just say, I knew there was a lot of attorneys, but to see all of their names on all of these certificates, insane. Let me get this off the screen for a sec, and let me pull this up, because I was like, what? The pages for the PDFs just scroll and scroll and scroll. And it literally is like, this is the ish that never ends. Yes, it goes on and on, my friends. She's already singing. Okay, here's one. So if we scroll down, this is all of Karen's. Now let me pop over for a sec, make sure that's good for you guys. No, that's very small. Sorry, guys. There we go. Okay. So these are all of Karen's attorneys. Now, essentially, they basically all just said the same thing. And this is for any of the attorneys. Basically, so say, just for instance, I have it in front of me, Karen Reed's team. It's all basically the same verbiage, and then all of their signatures, but separately on each separate documents. And then say, like, for the O'Keefes, they have like their own version or whatever. And then it's basically all of the same thing in all the different documents. So we have Aaron Rosenberg. A lot of these names you guys are going to know. Some of them you're not going to know. Oh, I should probably read it to you. So Karen Reed's team says certification in response to court order doc number 139 just says, I certify that I'm not aware of any facts to any dissemination to anyone other than parties and counsel in this matter of any of the contents of the material impounded by the court's order on June 8th, 2026. Then we have Charles Waters. I'm telling you guys, it's like there's so many. There's so many of them. We have Damon Seligson. And almost every single one of them were present too. Alan Jackson. Let me use my mouse for this. Caleb E. Mason, who is a part of Alan Jackson's firm. Elizabeth Little, hello. We miss you, Liza. We miss you. It was nice seeing your face today. Although you weren't in person, you were over the air, but that was nice. Thomas Tang. And author Maravellis. He was also there today. Michael Bell was there today. Sarah Shipley was not there today, but she was previously excused. And then Karen Reed. But do we think that's the end of it? No. No, of course not. Because of course there's more. Everyone's in chat. Everyone in chat is like, I want to know exactly what it is. God, we unfortunately, we don't know. Unfortunately, we don't know. And then we have, who are these for? Okay, this is for C.F. McCarthy's. Thankfully, there's less pages here. C.F. McCarthy's went in just to a tiny bit of more information. Certification of attorney Tamara Smith Holstag. She was present today. She says, obviously, I state under oath as follows. I'm a partner at the law firm of yada, 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 and she's the counsel of record for C.F. McCarthy's. I have not disseminated any contents of the material impounded by the order of the court on June 8th, 2026. I have no knowledge as to who, if anyone, has disseminated any of the contents of the materials impounded by the court to anyone other than the parties and or their respective counsel. So that is her. So we've got, and then they went a little bit more. Kristen St. George, we saw her for the first time recently. The last hearing. Alexandra Beaton, we have not seen her yet. Lincoln Rose, we've seen a few times. He was actually at the first hearing. I was re-watching that first hearing of this case, and I didn't realize he was actually there for the very first hearing. Steve Carey, You see what I mean, guys? There are attorneys working on this that we have never actually heard of before. And Gilmore Cassiano. If I pronounce any of these names wrong, of course, I apologize. It's never my intent to say names wrong, unless I do mean it. And then if I do mean it, you guys will always know if I mean it. No, legit. We'll get into this because I was present there today for this hearing, and the attorneys were attorneying. Is that a good way to say it? The attorneys were attorneying, and they all had different, we'll say, different expressions. It's the way that I'll put it. Expressions. Okay. This is for the O'Keefes. Okay. And they state, you guys see how all the different like parties, law firms, etc., all a little bit different, but they're all essentially the same thing. So this is from BBNFL, Certification of Counsel. I, BBNFL, assert the following to be true and accurate under the pains and penalties of perjury. I'm an attorney admitted to practice law in the state of California. My motion for admission pro hac vice in this matter has been granted by this court. I have not disseminated, nor am I aware of any facts regarding dissemination of the contents of material impounded pursuant to the court's order of June 8th, 2026, to any person or entity other than the parties and their counsel in this matter, signed under the pains and penalties of perjury this 29th day of June 2026. So there is BB Fell, who was present, by the way. She did fly into this. So not into this, but for this. Not into this. Unless she did. Then we have Christina Brillahante, is another O'Keefe attorney. Daniel Buck, we've seen many times. And Mark Diller. Marley Horwitz was also there. I think actually every single person from the O'Keefes was there. And then we have from the plaintiffs. So we have John O'Keefe Jr., who is John O'Keefe, Boston police officer's father, as well as Margaret O'Keefe. Another one from Margaret O'Keefe. Oh, she's signing for Kaylee. That's why. So that's John O'Keefe's niece, and Margaret, Peggy, John O'Keefe's mother, signed for the niece. And then Paul O'Keefe, John O'Keefe's brother. And also, I guess Paul O'Keefe did it twice. Nice. Good job, Paul. And then we have one more party. This is crazy. Do you guys see what I mean about how many, like, this is nuts. Like, we think we've seen them all. There's so many people behind the scenes that we actually don't know that all work very hard on this case. I think whatever side you're on, you all can recognize just the sheer huge nature of this case and just how many moving parties there are, which is why an emergency hearing like this is crazy. All right, last but not least, we of course have the Waterfall Bar and Grill. And again, just briefly going over their statements, their affidavits. Affidavit of David H. Hassett. Of course, we've seen him plenty of times. I, David F. Hassett, do depose and say I'm an attorney of record for the defendant Waterfall Bar and Grill in the above matter and a member in good standing of the Bar of the State of Massachusetts. On October 3rd, 2024, I filed my notice of appearance in this matter for the defendant Waterfall Bar and Grill. I hereby certify that I do not have any facts known to me as to any dissemination to anyone other than parties and counsel in this matter of any of the contents of material impounded by order issued on June 8th, 2026, signed under the pains and penalties of perjury on this day, 30th of June, 2026. David Hassett. And let me see, we've got Bridget Meehan. We've seen Bridget before. John Dealey, of course, we've seen before. Casey L. McCaffrey, we have not seen before. John Donovan. Oh, okay, that's who was sitting in front of me. Okay, John Donovan. Nice to meet you, John. I was wondering what party you were in. I was very confused. It was very overwhelming. Let me just say this. Now you guys can see just how insane it is to ask for every single one of these individuals to be present for something like this in 48 hours notice, less than 48 hours notice, give or take, is quite an ask. Not only that, for each individual party is quite an expense as well. especially when you have attorneys like Alan Jackson or BB Fell that do have to come from the other side of the country at a moment's notice on a holiday weekend, because obviously there are people that are already celebrating the 4th of July. People are already traveling. And as someone who had to drive down Route 3, people are already going to their Cape homes. So, yeah, I get it. It's a big ask. It's very expensive. Honestly, you want my opinion after this hearing? Just jumping ahead for a second, I think this absolutely could have been done on Zoom. Like, if you're a local attorney, come in. Come in because I want to see you. If you're in California, stay over there and go on Zoom. Because this is just I was talking to a few folks and I was like, this is costing them tens of thousands of dollars to have all of these guys appear. Like, for us layman people, just think how expensive hiring one attorney is. And now you have all of them. 34 in total. It could have been an email. You're right. It could have been an email. Where'd that go? It absolutely could have been an email. Here's the thing though. And you all know me a little bit by now. I do like to give a little bit benefit of the doubt. I can understand why, if Judge Gildea felt that something was leaked from an impounded document, a sealed document, I could see why he would want to pull everyone in. But after said hearing, I have I'm not so objective in regards to this hearing anymore. It's a lot of you guys have been saying a lot of things about Judge Gildea. I tried to be a little bit more middleman. Tries the keyword. So that was that. And then, of course, I just want to pull this up because there's always going to be someone that tries to say, well, so-and-so didn't show up. There's always someone reaching on one side or the other. So, of course, there were attorneys that were either excused or were allowed to be via Zoom for whatever various reasons. So, in Judge Gildea's order from yesterday, he stated that attorneys and I did break this down, and I'm having a brain bubble at the top of my head right now because I can't really remember. I think Attorney Beaton is crap. Where's chat? I literally did all this research yesterday. Attorneys Beaton, Shipley, and Waters are excused from having to appear in the hearing on July 1st. That is today. Shipley and Waters, of course, are Karen Reed's team. And then attorneys Fell, Hortzwitz. So those two both showed, by the way, They're for the O'Keefes. And then obviously Little and is it Maxon Mason for Karen Reed's team were able to appear on the air. I'll wait for you. Oh my God, chat's funny. And then just a fun graphic that someone sent me just to see the bulk of people, because wow, a lot of you are visual learners like me, and to see the amount of attorneys that are on this case it's impressive. It's impressive. There were a few people wondering if the O'Keefes had to be there. No, they did not. As long as their attorneys were there, and then they obviously signed whatever affidavit or whatnot, they did not have to be there. Karen Reed was there, of course, which I'll show you guys in a second. As well as Michael Proctor's attorney, Thomas DeGangi. We've heard of him before. If you guys remember the Rosemary Scapiccio statement, you guys remember that? I wish I pulled that up when she was like, she was totally fed up with all of it. And she was like, why are we protecting him? You know, and she said that quote where Michael Proctor was basically wishing death upon, you know, the N-word of it all. So DeGangi was there for that hearing. He was also at another Proctor hearing too. But that was it for attorneys. Now, I think it's important that we pull up. Well, before I get into it, I promised you guys what Karen Reed looked like. Gorgeous as usual. Now we can thank our friend Grant. Thank you, Grant, for getting down there. A lot of you were hoping that media would be there. Guess what? Media showed up. I was shocked. Shooketh. Shooketh. I'm like, hey guys, it's nice to see you from all the various channels or online websites. This is incredible. However, guess what ended up happening? Normally, when you have media credentials, you are able to tweet live or comment live, post live. Obviously, there can only be one camera in the courtroom, so they had that. The judge ordered that no one, not even media, was able to have any electronics out. Honestly, I was shocked when I heard that. I was like, no way. No way. What? What do you mean? What? Like this is what? So very clearly Judge Gildea was putting like his hammer down and being like, or I should say gavel, putting his gavel down, being like, absolutely not. None of this is happening. No one can tweet anything until afterwards, which is why no one, not a soul knew what was going on until A, we got out of there, and B, they immediately posted the stream. So that was another thing. So like immediately when I walked in, I was like, oh, this is like for real, for real. And you know what's funny? It's poor Grant was expecting to be able to use his laptop. And actually I could tell a few of the media folks were only had their laptops or their phones on them. And I had to give Grant a couple of pieces of paper because I was like, oh yeah, this is not the norm. This is not the norm. So I did give Grant a couple of pieces of paper. Of course, I always had a couple extra pens too. So I want to pull up Grant's video because, like I said, he was there reporting. He was there early to be able to catch Karen, Alan, Rosenberg, and a few of them walking in. So I'm going to pull up this video real quick so you can see what Karen was wearing, Alan Jackson, because I know you guys like seeing them in action, right? Action Jackson. Correction. This is them leaving. This is them leaving. It's fine. We'll roll the clip.
I think now would not be a good time for a comment, so I'm going to reserve all comment. Is that good?
What about the fact that you weren't allowed to make any case in front of the judge? What were you hoping to say?
So I'm going to reserve comment. Nice try, but I don't think we have any choice. Nice to see you guys.
Have a good 4th of July, Alan.
I can finally see what Boston looks like without snow. I didn't know. No idea. Oh, wait.
So even though it went a little bit left field with this hearing, at least they were in good spirits amongst all. But you could see that the whole crew was there, the whole crew. Now, before I get into the hearing, it's always important to remember the subject matter at hand. And I think some of us need a reminder in exactly who Michael Proctor is. And I want to go back to a little interview I did. If you follow me on Twitter/X, you'll know that I already posted this. But this is just a little reminder of who Michael Proctor was while he was appealing his job to get his job back. Because you remember he was put on suspension, and then a whole lot of McCabe, Higgins, Albert supporters sent in a ton of emails in support of him, Brian Tully, Yuri Buchanan, John Fanning. Weird. I still think that's weird. Anyways, this is just a brief little reminder of exactly who seems to be being protected right now.
What do you want to say to anyone who believes the narrative, the defense's narrative, that you are corrupt, that you framed Karen Reed?
I laugh because it's such a ridiculous accusation. There's not one piece of evidence or fact to support that, because it did not happen. I would never do something like that.
Did you crack the taillight to make it look a certain way?
Absolutely not.
Did you frame Karen Reed?
Absolutely not.
See how he was smiling? It was the smugness. And there's still quite a few of them that still walk around like that. Now, hindsight's 2020. We're flash forward, what, a year later? Because that interview was done after the verdict, where Karen Reed was found not guilty. Not guilty. What was that, chat? Oh, that's right. Not guilty. And now she's off probation. She did a year full of probation. No complaints. Did not get dragged back into court. Nothing. So, that was just a quick little reminder of exactly who we are talking about. Now, oh yeah, no, the smile. The smile. Oh, the smile at the end. He was real confident. Real confident. Until that second phone extraction came out. Oh, he's not smiling now. Oh no. Oh no. Family gone. Dog gone. Home about to be gone. Career gone. What seemingly is right, his mental health is gone. Apparently is what he's saying. Was it worth it? Like, was this actually worth it? And how much more are you going to put yourself through before you realize, hey, I'm the slaughter pig here. No one else is getting in trouble right now. We'll see. We'll see, chat. So, getting into all for what, right? Well, let's get into the hearing now. Thankfully, first of all, happy belated birthday to the trial channel. Thank you so much for being on top of this. Like, this is incredible when you guys see this, because I don't think any of the other streamers have gotten this yet. And I can't thank her enough. She's so amazing with all the edits that she does. She has different angles and whatnot. So incredible. She fixes the microphone issues for us. Like, top tier. So if you are not subscribed and you don't go and watch her stuff, please go do, because she has everything on there and she really does go above and beyond, truly. So again, thank you and happy belated birthday. Let's get into this, folks. Okay. Hope you guys are ready for some honest tea from me, because I have thoughts. I have lots of thoughts. And I swear to God, if an advertisement plays. Okay.
This court now is session. Please be seated.
Your Honor, may I proceed?
Yes.
Your Honor, for the record, Civil Action 2483 CV 0692. This is Paul O'Keefe, individually and as personal representative of the estate of John Joseph O'Keefe III, et al. versus CNC Hospitality, LLC, doing business as CF McCarthy's et al. Your Honor, with your permission, at this time, I will call the names of the attorneys in attendance and ask that they state that they are present for the purposes of the record.
Thank you.
Attorney Brillahante.
Present, Your Honor.
Attorney Horwitz.
Present.
Attorney Fell.
Present.
Attorney Buck.
Present.
Attorney Diller.
Present.
Attorney Beaton has been excused, Your Honor. Attorney Holstag.
Present.
Attorney Rose.
Do you guys see? Now picture us in the back, right? And we're just like, we are surrounded by attorneys. So where the jury was the bar attorneys. So CF McCarthy's and the Waterfall, as well as a few of the O'Keefe attorneys. So, and then you clearly see the 5 chairs at the other desk, Karen's team. Well, I should say 5 of Karen's team. Then in the first row, where we actually have seen Karen Reed and her parents sit before, was actually Proctor's attorney, and then Donovan, who was another one of the bar's attorney. And then the 2 rows behind that were us, public, the spectators. On the other side, the very first row was all media, and then we had 2 more rows of spectators. So like, you can just imagine walking into this, like, every seat was filled, and more than half of the courtroom were attorneys.
Attorney St. George. Attorney Donovan. Attorney Daly. Attorney McCaffrey. Attorney Hassett. Attorney Maravellis. Attorney Shipley has been excused. Attorney Tang.
Present, Your Honor.
Attorney Bell.
Present.
Your Honor, Attorneys Little and Mason are appearing via Zoom.
Yes, Your Honor, present.
Present, Your Honor.
Jackson's getting some free.
Okay. Everyone and their mother was freaking out about that. And guess what? I'm just going to say this too. We also in the rows, the spectators were like, "What the hell was that?" Now, if you're looking behind Buck's head, let me see if I can shift it back a little bit. Okay. You guys can see, obviously, on that huge television, this huge guy right there, that is where some of the Zoomers are. Now, Judge Gildea said it, and all of us were like, what? Like, even Karen was like, the hell was that? like, we weren't expecting that. Now, at first, we thought it was a bad thing, right? And I think the bulk of you that were here online watching all also thought it was bad. But now that we see what Judge Gildea was seeing, okay, now I can understand, because you've got the huge Worksman, Jackson, and Quinn LLP sign, right? And if they were on a regular Zoom call, I think it would be funnier, because like everyone would be like, oh, haha, like, yeah, we're all in on the joke because we all can see. The problem is the only ones that can see that obviously is the court, maybe a handful that are in the jury that for like the Waterfall or CF McCarthy's, and then Alan Jackson. No one else is aware. No one else is aware of what was going on. We were all lost, guys. We were all like, what the hell are you talking about? And like, obviously some of us were like, oh, that was kind of rude. We weren't in on the joke. That's the problem. We weren't in on the joke. You can't tell a joke and not have everyone in the room not know what you're talking about, because that seems like it's mean. Like, but yeah, all of us had the same expression. We were like, the hell? So now when he says it again, look at Alan Jackson's face. So peer over to Jackson, because he chuckles at it. Meanwhile, everyone else is like, what, the duck?
Attorney Daly.
Present, Your Honor.
Attorney McCaffrey.
Present, Your Honor.
Attorney Hassett.
Present, Your Honor.
Attorney Maravellis.
Present, Your Honor.
Attorney Shipley has been excused. Attorney Tang.
Present, Your Honor.
Attorney Bell.
Present.
Your Honor, Attorneys Little and Mason are appearing via Zoom.
Yes, Your Honor, present.
Present, Your Honor.
Jackson's getting some free publicity as well. For
Attorney Jackson.
You see him? You see him? You see Jackson? He's giggling. He was giggling. But also we were like, oh, okay. So that's what that was about. See, I told you guys, I'm here to talk about what was going on in the room and give a little more context. So that was that dig that we all thought was like a big deal. Even Rosenberg is laughing at it too. So we'll take it. We'll take it.
Attorney Seligson.
Present.
And Attorney Rosenberg.
Present, Your Honor. You can sit down. Thank you. So thank you, counsel, for being here. I scheduled today to be in person because of the significance of what I was advised of last Friday, and because I find the quiet solemnity of the courtroom is a good reminder of the dignity by which courts are supposed to function. One commenter describes how every high-profile case now unfolds in two arenas.
What commenter is he talking about? This made me, like, I literally have down on my notes, thinking that he's about to quote someone, and he says, one commenter says, and he goes on, do you guys remember when he had admonished, if, Oh, is there a troll in the chat? Let me take care of it. When he, I guess you wouldn't call it a full admonishment, but when he was like to Rosenberg, when he was quoting something from Alan Jackson, the pin it on the girl quote in a previous filing. And I agreed with Judge Gildea that he needed Rosenberg, Waters, Seligson, whoever put that in the paperwork should have cited it properly. I do agree with that. But now here he goes saying like, oh, this commenter. And I'm like, what comment are you talking about? What are you talking about? I don't know in particular what person you're what? Right? It's like, where did this quote come from? Who are you quoting? It doesn't make sense. It doesn't make sense. Anyways, he goes on.
One governed by procedure and precedent, and the other by pixels, edits, and algorithms, and how the courtroom has become content and the law has become a spectacle. I recently held a hearing on a non-party motion for a protective order. I required the moving party to provide certain information. Such material was filed together with a motion to impound. A hearing that included the motion to impound was held on a Monday morning. I allowed the motion to impound during the hearing. The affidavits of the moving party and the attorneys were impounded. Following that morning hearing, I found that there was insufficient information to support a delay in the deposition of the non-party from going forward. However, I further found that given the claims made in the filings, I would delay making a final decision on the motion until later that day to give the non-party's counsel the opportunity to supplement the record before me. I scheduled the matter for further hearing that afternoon at 4:15 with the expectation that there would be additional filings. At 2:22 p.m. that day, the non-party's attorney emailed the clerk of this court and all counsel of record, excepting one.
Okay. That timing is important because 2:22 p.m. was the timing of that 112 document filing, as well as document filing 116. Pin that in your head for a second, guys. We'll come back to that.
Additional materials in support of the motion for a protective order. The filing included a motion to impound additional materials. Exactly 30 minutes after the email to counsel of record of the additional material, which included sensitive and private medical information. Similar information to what was in the exhibits to the filing and marked provisionally impounded was posted to an X account at 2:52 p.m.
Now remember that time, 2:52 p.m.
Upon learning this information, I ordered that the parties and counsel provide certification to the court as to all facts known to them as to any dissemination to anyone.
Now my question is, chat, he says someone found out. He found out. I need to reverse this for a second. Who told him? I was sitting there taking notes being like, is he not going to say who told him?
Originally impounded was posted to a motion to impound additional materials. Exactly 30 minutes after the email to counsel of record of the additional material, which included sensitive and private medical information. Similar information to what was in the exhibits to the filing and marked provisionally impounded was posted to an X account at 2:52 p.m.
Who?
Upon learning this information, I ordered that the parties and counsel provide certification to the court as to all facts known to them as to any dissemination to anyone other than parties and counsel in this matter of any of the contents of the material impounded on June 8, 2026, and I scheduled this appearance for today. I received certifications from all party and counsel, 32 of them in total. No one apparently has disseminated, nor are they aware of any facts regarding the dissemination of the contents of impounded material to any person or entity.
Yeah, because not for nothing, and I know everyone feels a certain way about all the different parties. I do not see any of these parties pulling some fuck shit like this. I just don't. I mean, we're talking about medical information here, right? And whatever Proctor put in his filing, I do not see any of these attorneys going to Joe Schmo down the block and being like, hey, did you know Proctor's diagnosed with blah, blah, blah? I don't see that happening. But if we're just giving or getting context clues from the various filings, the hearings, what Proctor has recently been through, town rumors, the selling of his house now, obviously anyone in that point of their life is not having a good time. I don't think that is a rush to judgment. I think you would be odd if you weren't having a hard time or maybe going through depression, anxiety, whatever. But like I've said before, that depression and that anxiety is self-imposed. Just like what Judge Gildea said about Colin Albert's deposition. Self-imposed. I don't get it, chat. I don't know.
Other than the parties in counsel in this matter. However, somehow, an ex-account holder, not part of this case, apparently received information that was at least provisionally impounded.
Here's the deal. Chat. Raise your hand if you have ever gotten information that was, some weird stuff. Maybe it's a rumor. Maybe someone saw something somewhere. Maybe it was on, the Registry of Deeds. Who knows? But raise your hand if you think Michael Proctor's going through a hard time. It doesn't mean you have to feel bad, guys. Right? I mean, I think it's a little obvious. But at the same time, as just one out of many who has individuals reaching out to her all the time in regards to a whole lot of stuff. Obviously, you can find out, we'll say drips and drabs of information, and then it doesn't mean anyone leaked anything via an impounded court document. That is not a hard reach. Truth be told, I was like, okay, looking at this afterwards, I was like, because a lot of people were talking about Grant's post, so we'll get into that in a second. I was like, it's either Grant, it's either Aiden Turtleboy Carney, or it's me. Because we're like the three people that have been talking about this nonstop. Thankfully, it's not me. I did not post at 2:52 p.m. All right, we'll continue on. But you know what I mean? It's like, I just want to tell the ethers that are watching this hearing thinking like, oh, well, one of the teams definitely leaked something. No, it's actually very possible that one of us heard something through the grapevine. Like it happens all the time. And guess what? We as, I don't know if you want to call me just like a Norfolk County resident, or if you consider yourself a journalist or a blogger, a YouTuber, a streamer, whatever you consider yourself. It doesn't really matter because we don't have to talk to the attorneys to find out stuff. And obviously, all of you know all that if you follow me or Aiden or anyone. We all see this clear as day. But it seems like Judge Gildea may have jumped through a hoop and then just went down the rabbit hole. And at the cost of tens of thousands for each of these parties. So
orders of the court have been violated either directly or at the very least in spirit. If these orders are to have any effect, all parties involved must operate with integrity. Rule 13C of the Uniform Rules of Impoundment Procedure imposes a duty on all persons to protect the confidentiality of impounded material. Additionally, Rule 3.6 of the Rules of Professional Conduct prohibits lawyers from making extrajudicial statements that they know or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. In cases like this, where all parties involved are aware of the public attention, I expect that everyone is taking every precaution to preserve confidential information, to follow the rules of the court, and to adhere to my orders. Because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. If necessary, I am
Oh my God, I'm muted. I'm so sorry. Oh my God. If you have the emoji that has the mute, feel free, if you're a member with the mute emoji, just feel free to, wow, blow up my chat. You know what? I am blaming the heat. But anyways, like I was saying, to pause a deposition of someone like Michael Proctor, the discovery and the deposition, because that's what he means. This is not just, now everyone's going, shh. This is, me personally, just thinking of who Michael Proctor is in the scope of the investigation, Proctor and Goody, which are like obviously the two biggies right now. Think of them, who they are in all of this. And now you want to pause anything related to Proctor in this case because you think someone leaked something from an impounded document. But had Judge Gildea probed a little bit more, which we'll get into, this all could have clarified at the hearing. This all could have been clarified for all of us. All of us. Chat, I'm so sorry. It's because I picked up my drink and I didn't want you guys hear me drinking. So, sorry, guys. All right, continuing on.
stayed further discovery of the non-party. If necessary, I am fully prepared to make such order permanent as permitted by Rules 26 and 30.
Oh, so if these shenanigans continue on, you're not going to be able to depose Proctor at all. That's what he's saying. Discovery of Proctor will be done. Kaput.
To any issue counsel may raise as to the management of discovery issues being within my discretion, I invite you to look at the following cases. In the 2003 case of Buster v. George W. Moore, Inc., 438 Mass 635, the SJC stated at page 653, in general, discovery matters are committed to the sound discretion of the trial judge. In a 2002 appeals court case, Mattoon versus the City of Pittsfield, 56 Mass Ave Court 124, the court stated at page 131, trial judges have broad discretion to make discovery and evidentiary rulings conducive to the conduct of a fair and orderly trial. In the 1987 case of Solomon A. versus B. Gruhl, 399 Mass 790, the SJC stated at page 799, the conduct and scope of discovery is within the sound discretion of the judge. In Cronin versus Strayer, 392 Mass 525, a 1984 case, the SJC stated at pages 535 to 536, we remind judges that the scope and timing of discovery is within their discretion, and the prevention of discovery abuse is sufficient justification for the authorization of protective orders.
So I just wanted to answer this question really quick from Beth Bay State. Isn't that obstruction preventing a deposition? No. No, it can be a sanction. In layman's terms, if he thinks something funky is going down, he can absolutely do all of the things. And that's what he gets into. As a judge, he has that authority. So it's not obstruction. Now, the issue would be, would this hold up in an appeals court? You're asking me, I don't think so. Because like I said, had he probed a little bit more, maybe he would have had a little more answers. You know? Oh my God. Who posted? We don't know who posted. We don't know anything. We literally know nothing. Is he confirming the rumor? Good question. Good question, because that's what it sounds like. He's confirming whatever was put out there.
With this authority at hand, judges should not hesitate to exercise appropriate control over the discovery process. And finally, in the 1987 case of Campagna versus the Board of Directors of the Massachusetts Housing Finance Agency, 399 Mass 492, the SJC stated at page 503 that Rule 37 affords a judge broad discretion to impose whatever sanctions are just in order to ensure that the discovery process operates efficiently. The malicious publication of private information concerns me. Whatever opinion that one may have of a non-party, even if warranted, such an opinion does not allow for the disparate treatment of such individual.
Well, here's the deal. I think any of us who have seen anything coming out of Proctor recently don't have any sympathy for him. I mean, empathy's out the door. Empathy's completely out the door. You can only be empathetic towards Proctor only if you feel the same way that he does. So now, does that mean we can do all the things to him? Absolutely not. Like he says, things have to be done with discretion. However, any of you that feel a certain way about Proctor in regards to the filing of Karen Reed's complaint against Massachusetts State Police and Canton Police Department, your feelings are valid, more than valid. Obviously, we had more of that information come out in Rosemary Scapiccio's motion to dismiss that was finally unsealed. And guess what? That was only unsealed because of Karen's filing. Literally. Even Rosemary Scapiccio was like, what is going on with this? Why are we protecting Proctor? And I just know Scapiccio watching this hearing is like, what the hell? What the hell all over again? All because what's seeming like either A, he thought someone leaked an impounded document, or B, someone has a source with information regarding Proctor and his whereabouts. That's insane and should not be put on any of the attorneys. No attorneys, no defendants, plaintiffs, none of them. should be having to pay for this stupid hearing. Now you guys are really going to get how I feel. Waste of time, waste of money. Like, this is exactly how I feel. And here's the deal. You guys know I try to be objective, and I try to, and I do, for the most part, like Judge Gildea. And even though I don't agree with everything, there's a lot that I can't agree with. But this is just so many hoops to jump through. And it just seems like you're just trying to pick at something to do something to someone. You know what I mean? And we'll get into the attorneys afterwards, because I have a little suspicion of what may have happened. And we'll finish the hearing and then we'll talk about it, because I have questions. Okay.
It does not allow for the disparate treatment of such individuals. All people deserve fair and equal treatment in our system of justice.
That goes towards anyone that had Proctor as a lead investigator. So that also needs to be afforded to defendants like, I don't know, Karen Reed. Oy vey.
Regardless of any personal characteristic, as abhorrent as some of them may be.
Abhorrent is not even the beginning of to discuss what Michael Proctor is, because it's not how he feels, it's who this man is.
What I am looking for is for the parties is adequate assurances that their discovery served justice and not any desire to weaponize the rule for pettiness and profit.
More
No.
boxes, more
Oh
options.
my God.
Granger has over 1,700.
That is rude. Rude. Rude, rude, rude.
If the parties in for pettiness and profit, if the parties and lawyers would enter into an agreement to hold private personal information in confidence, and if the terms were acceptable to me, I would consider entering it as an order of the court so that any violation would be grounds for a contempt finding and appropriate sanction, including dismissal or default. Such an order would need to be more than a stipulation that deposition testimony can only be used for the purposes of this case. I encourage the attorneys to confer and to seek to reach an agreement.
Yeah, but an agreement on what? Every single one of them signed their own affidavit. After David's. Everyone signed and said, we didn't leak anything. So perhaps, Judge, maybe there was a source that told someone something. Good Lord. Like, he's immediately jumping to the fact of someone leaking something. Maybe one of the attorneys reached out to him and said, oh yeah, we think someone did something and this is what we were told. We'll get to that.
In the absence of an agreement, I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery. While you are conferring and seeking to reach an agreement, I will again remind you, as I have quite often, that the discovery clock is ticking. My final request to counsel with an appearance in this matter is to familiarize yourself with Rule 3.6 of the Rules of Professional Conduct relative to publicity. The rule sets forth a basic general prohibition against a lawyer's making statements that the lawyer knows or should know will have a substantial likelihood on materially prejudicing an adjudicative proceeding.
If you are saying that no one can continue anything in regards to Michael Proctor, which is essentially what he's threatening, doesn't that put unnecessary prejudice on everyone? Obviously not the O'Keefes, because they literally don't care. They are there for the deposition, but they have said, like, either which way, they don't really care. But what about the other three parties? Don't they matter too? This is wild. He's threatening to cancel the whole case. Default by judgment.
The rule applies to lawyers who are or have been involved in the investigation or litigation of a case and their associates. As the comment to the rule notes, it is difficult to strike a balance between protecting the right to a fair trial and safeguarding the right of free expression. However, preserving the right to a fair trial for everyone necessarily entails some curtailment of information that may be disseminated prior to trial.
Michael Proctor is not on trial. Not yet, at least.
Especially where trial by jury is involved. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence. The rule takes into consideration that the public has a legitimate interest in the conduct of judicial proceedings, particularly in matters of general public concern.
Okay, so he understands that the media is necessary and that Zooms are necessary when obviously everyone can't get together, because this is crazy to expect every single attorney to be at every single hearing. But it seems like at almost every step of the way, Judge Gildea is not a fan of technology. And I get it. There's bumps and bruises and all of the things, right? Internet messes up, Zoom messes up. They have to change courtrooms. You got to move the camera. I get it. And I understand that courts can be behind on technology. That's actually something Emily D. Baker talks about all the time. All the time. She's like, yeah, the technology in this courtroom sucks. Do you remember for the first Karen Reed trial, they had to get new TVs? And then they were trying to figure out where to put Tiny Desk Man, because they originally wanted him at the desk, but then there wasn't, like with Karen and the team, but then there wasn't room. So then they had to put him to like a tiny, like little a dinner TV tray on the side and then figure out where all the wires go. I mean, they didn't even have proper air conditioning in that courthouse. So I get it. The judge is not a fan of technology, but I think it's time we get with the times and realize that technology is crucial to court proceedings. I mean, hello? You want them to confer and do all these things. Well, then how do they do that? They do that via technology, via emails. I don't know. You guys know I'm usually objective, but this one, this hearing made me go, woohoo.
However, I'm not so sure that churning the waters to generate social media coverage necessarily can result in a legitimate interest in the conduct of judicial proceedings.
And what do you think this today did, sir? This churned all of the waters. All of the great white sharks on the beaches of Cape Cod are spinning right now, sir. You just did the opposite. This is the actual definition of Streisand effect. Or as we like to lovingly call over here, the new age Afro Man effect. Like, what do you think you are doing by doing this? You had not only Alan Jackson, but BB Fell from California fly out for this. And I thought it was very interesting how BB Fell was allowed to stay in California if she wanted to, but not Alan Jackson. I have questions about that. That to me seems a little odd that Jackson had to fly over, but Fell was excused. But like I said, Fell showed up anyways. It doesn't make sense. It doesn't make sense. It doesn't make sense.
Read the rule, especially if you have never done so. Adhere to it, or be ready to face the consequences for failing to do so. I remind counsel of what one commentator called the quiet expectation of fairness that we have as citizens.
Another commentator. Who? You cannot scold an attorney for not having proper citation. And then when you're at a very emergency special hearing like this, also do the same thing. You guys will quickly learn on this channel if you don't follow me on TikTok or Twitter. I very much do not like a hypocrite. I do not like when someone says they don't like when someone does something, but then they do it themselves. It just irks me to my core. It gives me like a lack of integrity. Now, I'm not saying obviously Judge Gildea has a lack of integrity. However, I do find it very interesting that he did that on one other side, but then on for this, he's just saying commenter. You know what I would tell all the attorneys at this point? Just do it. Just don't. I'm kidding. Don't do this. But it would be kind of funny if you guys were just like, oh yeah, and this commenter said, don't do it. He'll probably sanction you now because now he's like really mad. But like, what if you did? All of you as a team, all of you, all of the sides. That's just me being petty. That's just me being petty.
Such expectation is based on the framework the founders of our country built 250 years ago and trusted future generations to maintain. Counsel, do your part to maintain the quiet expectation of fairness. Do not succumb to the attraction of seeking to influence this case through social media. Be what a trial lawyer should be, one that tries their case in the courtroom. And remember the provisions of General Laws, Chapter 221, Section 28, relative to the oath of office for an attorney in Massachusetts, which provides, in part, I solemnly swear that I will do no falsehood. I will delay no man for lucre or malice, but I will conduct myself in the office of an attorney within the courts according to the best of my knowledge and discretion, and with all good fidelity, as well to the courts as my clients. So help me God. I wish all of you a happy 4th of July on the anniversary of our America's 250-year-old democracy. May it continue to succeed with all of us working to maintain the rule of law. Thank you.
I'm pausing it here because, like I said, I was at this hearing today. Let me just tell you, when he got up like this, when he said, I hope you all have a good 4th of July, and he's walked on out. When I tell you, every single person in that courtroom was like, what the hell is going on? What do you mean all of these attorneys are here right now? None of them can make arguments. None of them can ask questions. Oh no, chat. Every single person in this room was like, what? What? Every spectator, every person in media, every person that was attorney there, even the court clerks, everyone was like, and I was like, no way, no way, no way, no way. Because my immediate head goes to, okay, you have all these attorneys here. Nothing's going to come of this. Nothing. But then watch this. Like, you can't make this up. Also, by the way, if you guys didn't see, right at the corner here, that's Evan Wolk from the Karen Reed trials. Remember, he was just a little baby attorney. And then he got hired by Alan Jackson. And now here he is with the big guns, sitting right next to Liza Little. So cool. All right, let me reverse this for a second, just so you can see.
May it continue to succeed with all of us working to maintain the rule of law. Thank you.
For the record, this matter is continued to July 10th, 2026 at 2 p.m. for hearing on.
Look over at Karen's side right now. Look at Seligson leaning forward. Jackson's like, what? Rosenberg is confused. When I tell you, everyone in the room was like, what the hell? So this is when you're going to hear Seligson say something, and then Jackson is louder. Jackson is very good at projecting his voice, as we know. and even though Bobby's not here, Bobby Alessi, What could be more egregious? I love that man. Okay.
For the record, this matter is continued to July 10th, 2026 at 2 p.m. for hearing on motions to compel the criminal fourth session.
Court stands in recess.
There's no opportunity to be heard.
So Seligson goes, there's no opportunity to be heard.
Court stands in recess.
There's no opportunity to be heard.
There obviously no opportunity to be heard.
I was
And then Jackson goes, obviously there's no opportunity to be heard. Like what?
There's no opportunity to be heard.
There obviously no opportunity to be heard.
I was unaware. I'm just covering for Clark Donovan today.
Is there an opportunity before anybody departs to let the judge know that we would like to be heard?
I absolutely.
Thank you. That's it. That's it. One second. Yeah.
Now just picture all of us in the courtroom right now. Picture all of us. Because Seligson and Jackson were like, hey. As when Jackson, obviously the court clerk was like, okay, so I wasn't aware. I'm covering for someone. And Jackson's like, can you go get him, please? And so thankfully, Trial Channel, you can hear the court clerks. You can hear all the whispering because everyone's like, what is going on right now? What is going on? All right, let's finish this up.
Correct that record.
He's not going to let us be heard.
So you can see him. He comes right on back and he shakes his head no. And Seligson's like, he's not going to allow us to be heard. Look at this guy's face, the court clerk. He's like, no, I said no, now leave.
He's not going to let us be heard.
Well, we'll use that as another.
So here's the deal. Here, let me get rid of this real quick. Okay. Now I get to talk about what I saw after this happened. So obviously Judge Gildea said no. Court clerk, at least the court clerk was nice and went and asked. Very nice. And then we briefly heard Jackson say something at the very end, like, okay, we'll just blah, 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 blah. Maybe something like, we'll use it for something else. So I was seated, like I said, in the second row, and I actually was right behind Proctor's attorney, DeGangi. Now, would it surprise you all to know that once Judge Gildea basically went off that bench, basically running away, DeGangi did not stay. He did not care. He just up and left. So even if the judge was going to come back, DeGangi was like, nope, deuces, I'm out. Bye. See ya. Who would have thought, any of the attorneys, that this hearing was only going to be 15 minutes long and it was only going to be Judge Gildea having a speech? No one was expecting that, obviously. Obviously, each party had a game plan. Now, it looks like from where all the attorneys were, the main people that had game plans were Reed's team and O'Keefe's team, obviously. But then here's the thing. I not only go to these hearings because I want to be there in person, because I do feel like there's something different when you're in the courtroom getting the vibes. And this was definitely a contentious hearing. The room definitely felt like the air felt tight. It felt like there was a lot of tension. Then when Judge Gildea left the bench, Obviously, Karen's teams are doing their little chit-chattering. Mark Diller. Sir. If you guys don't know, Mark Diller is the O'Keefe's main attorney. I think we all need a reminder that he's the one that significantly misquoted Karen Read. That exhibit that he used, he got from Twitter. He got from Twitter that magically Jennifer McCabe's best friend was posting. And the reason why we know it's that one is because the filing literally had the date and time of when she posted it. And it was also the sped up recording of Karen Read of this phone call. And then when it was pushed back, how funny it was pushed back, obviously, because he misquoted her. If this was the whole, if you guys remember, Diller was saying that Karen Read said, "I'm dead, I'm fucking dead," in regards to her not getting her cell phones back from the Norfolk County District Attorney's office, because I cannot believe they still have her goddamn cell phones when she's been acquitted. You let her have the vehicle back, but not the cell phones? Then, when Karen's team pushed back, if you guys remember this, you were here for that, there were so many filings flying back and forth between the parties. Frankly, it was quite exhausting trying to keep up because they were just throwing bows back and forth with one another. Finally, Judge Gildea asked Diller for this exhibit in a thumbnail or thumb drive. Because, again, like I said earlier, Judge Gildea does not like technology. So, Diller did give them an exhibit. In fact, labeled it as the same exhibit, Exhibit J, but it was, in fact, a different recording. It was slowed down. It was a different Twitter post. It was completely different. Interesting how he did that, referencing Twitter. And just a sidebar, we need to remember who also did the Twitter of it all for exhibits. Oh, that's right. Attorney Tuxbury. In regards to Colin Albert's deposition, where he actually used commenters underneath one of my tweets to prove harassment or whatever, which is interesting because Judge Gildea obviously didn't want any of that either. So, here we are at the end of the hearing, like I said. Karen Read's team, they're all doing their chit-chatter. Mark Diller, after Seligson and Jackson wanted to ask if Judge Gildea could come back, and obviously the court clerk came back and said no, Mark Diller started laughing. 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 Like I said, I was sitting in the second row. I had a clear right shot at him. He just fucking lit up like a Christmas tree. Which makes you wonder, given all of this background stuff. Obviously, there's no proof of anything. But it would not surprise me, later down the line, something comes out in regards to all of this. I don't know what. However, I found it severely inappropriate to be laughing, considering how much the O'Keefes, even if they're not spending the money now, how much the O'Keefes just had to spend to fly out BB Fell. You know what I mean? That's why I kept saying this wasn't just Alan Jackson flying out. This was also BB Fell for the O'Keefes. That is expensive. Even if Diller and Fell are on contingency, eventually that payment has to come from somewhere. Obviously, that side's going to say, well, Karen Read's going to lose, and the money's going to come from Karen Read or the bars. I verbally said out loud, because I was sitting next to the Reads, oh, look at Diller laughing. And then Diller turned around and looked at us. It's not funny for any of this. This entire thing was a waste of money. The entire thing was a waste of time. And there's Diller giggling. Well, guess what? I'm still laughing at the fact that it's the O'Keefes because of Diller's actions and Diller's filings. The O'Keefes have to spend thousands of dollars to not only pay for Karen Reid's storage of the cell phones because of that previous matter I just talked about, but they also have to pay for the experts. So even though Judge Gildea didn't sanction the O'Keefes, they were essentially sanctioned by the foolery of it all. So then just to stand there and start laughing? Okay. Honestly, guys, I was like, this is not real. This cannot be real. So, with all that being said, here has what's been going down on the interwebs since all of this happened. I'm going to pull out one thing that I've only seen a couple of people speak about. However, if we're going to start talking about people leaking things and people having claims out there, we have to talk about this. We have to talk about this. Whose phone number ends in 18? That's a clue to the poster of the leak. If you're not familiar with this person, don't worry. She's one of the spokespeople for O'Keefe, Higgins, Alberts, McCabe's, whatever you want to call her. I'm sure all of you know of her. I don't know if she is lying. I don't know if she knows something. I don't know anything. However, if we're going to be talking about Twitter leaks and all of things, and this one side in particular is going to say, oh, well, it's definitely person XYZ. And then someone on that side also posts things like this. This needs to be noted and flagged. And I hope every fucking attorney is talking about this right now, because what is this? Are you bullshitting? Are you lying? Is it a fairy tale? Are you just trying to do this for whatever clicks and views? I don't know. And obviously everyone in chat's like, whose phone number is that? I have no idea. But I saw that and I was like, okay, so if that one side is going to continually blame the other side for leaks and whatnot, and then you have the O'Keefe's attorney laughing at the end of this hearing after Karen's side is trying to get the judge to come back for at least some kind of clarification, and then this pops up. You can't say it's only one side when there's things like this that pop up all the time. Isn't there like a phone extraction and stuff going around too? Which by the way, that phone extraction still has no conversations between Karen Reid and Turtle Boy where Karen Reid says she did it. I'm still waiting. It's been months at this point. You want to talk about jumping through hoops? Who's pandering to the judge? Also, who's pandering to social media now? It's not a good look. So here was the first thing that we all thought it was. Poor Grant. Now, the reason why many of us thought this was it was because of the time that Grant posted this. So if I pull up my next screenshot, you can see the time. Where's my finger? 2:52 p.m. right there. So I immediately had questions about it. I was like, if this really what it is, Grant is just posting a filing that was on the docket. And as you can see, the first person who pulled it was Kyle Sharkey. But again, it was on a public docket. It was easily able to be pulled up. So this is not anything in regards to leaking. It has nothing to do with Proctor's affidavit or the attorney's affidavit, the apparent doctor's note. It's literally just the filing. But then this is why I didn't go live right away, because I wanted to see what was out on the interwebs. Someone pulled up a screen recording of the docket and was like, oh, Bandit. Sorry, that was my beagle if you heard him. Sorry. Sorry, guys. Chat's like, what the hell? Oh, God. Oh, am I flip-flopped? Okay. It's a mess. We're a mess over here. So then here's the thing. Someone pulled up a screen recording of the docket and was like, no, wait. He's referring to, if we go back to the number, the document number is 112. Well, the filing that Grant pulled up is not 112. Let me pull that down. It's docket 116 that Grant posted. Let me pull that up again for you guys so you can see it. 116. So the timing of Grant's tweet obviously aligns, right? But let me go, where is it? I'm pretty sure I have it somewhere. There we go. Right underneath my logo, you can see. That is what Grant posted. It was nothing about 112. I was like, okay. So either one or two things happened here. Either the court just automatically assumed that this was leaked, maybe got the docket number messed up. Maybe. Or, because I know chat's eager, everyone was talking about Aiden's tweet. Let me go. Aiden's tweet. So I saw a lot of chatter on this too. And Aiden tweeted on June 8th, but this was at 10:52 a.m. Michael Proctor decided to have a mental health crisis after the whole world found out how racist he is. Sources tell us he checked himself into a mental health facility in Florida to try to avoid today's deposition. They filed a motion at the last minute on Friday to delay the depo, but the judge wanted proof. They submitted an affidavit that was impounded because it likely said Proctor was in a mental hospital. Doesn't say definitively. Karen Reed's lawyers made the mistake of saying the scheduling of the deposition was strategic, which the judge took issue with based on her comments on the Today Show. He stayed the depo for 24 hours and at a 4:15 hearing will be held. My guess is he's going to tell Proctor to jump on a plane and stop being such a wussy so Alan can depose him tomorrow. So what other people were saying is that the time zones or whatever, right? Because this was at 10:52 a.m. And if you do UTC time, or if you do a different time zone, maybe that's what they were talking about. Because yes, it's true. That obviously has to do with Proctor's mental health. Specifically, it talks about him going into some mental health facility in Florida. So maybe that was that. Because the clues in the context of what Gildea was saying, something along the lines of this. Something along the lines of this. Then we had DUI guy. And I was like, okay, here's another thing it could be alluding to. So DUI guy, Larry Foreman says, I love and trust my fans. A lot of you email me with tips, suggestions, and compliments. This is an email I just got. I've never heard from this person before, so that's already sus. Source, trust me, bro. Larry. Could be the McAlbert's camp. That's another thing. Put that in your head for a second. Could be the McAlbert's camp. Could be legit. You decide. But this wasn't until today, July 1st at 11:46 a.m. But worthy to speak about because it's kind of similar to what Aiden said. This person's email goes, "Hi, Larry, love your content. I have first-hand info that Proctor's estranged wife leaked his mental health info well before the info was given to the court. She shared it with her friends that shared it with their husbands. One of those husbands is my coworker that shared it with me." So this is like through the grapevine. "That info eventually got to Turtle Boy well before the court ever heard of Proctor's motion to delay any deposition." So, again, that's along the same lines. And now that we know that he's living with Courtney, his sister now. He's not at the home with Lizzie, and Lizzie is now putting the house up for sale. I did see something also to public records or something related where someone was able to pull that there was some kind of mortgage or something put on it or something like that, maybe in like December timeframe of the last year, which that would make sense if you have to pay for it attorneys. You can put that against your own mortgage. So there's a couple of things with that. And I was like, okay. Now I'm getting confused because it's either this or it's either this. Grant's time matches, but Grant's tweet is based on a filing that is still there. Because at first I was like, did they pull down this document? No, it's still on the docket. Okay. That wouldn't make sense why the judge would pull in everyone for this. Maybe this. But again, that is such a leap if this is what it is. But like, really? Really? Oh, yeah. Everyone's like, oh, that would make sense why they put out a second mortgage. Yeah, because attorneys are expensive. And that's my whole point here. This shit is ridiculous given the context. If this is what it's about, no. 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 So like I said, I had a little moment pause before I came live because I wanted to get others' opinions. So I got others' opinions. Like I said, I watched Melanie Little, Lori and Defense Diaries. I got like little snippets of everyone. So this is what Bob and Allie tweeted. So they are saying, in the O'Keefe versus Reed et al. Matter today, Judge Gildea stated that an X post, a Twitter post, was posted 30 minutes on 6/8/26 after the two exhibits that were attached to Proctor's motion to provisionally impound materials. All I can find is Grant Smith Ellis post at the indicated time. I love how everyone calls him Towel. And all that Towel posted was the motion itself, which was not impounded, in which Grant merely echoed the language contained within the motion itself. That's not a leak. It's not even a drip. In my estimation, this was much ado about nothing. It was an opportunity for the judge to essentially gag discovery in the case by suggesting that the attorneys for the parties come up with their own self-policing agreement. And if they cannot reach said agreement, he will be drafting a permanent order regarding same. It was a very curious hearing, and frankly, I found it shocking that he did not allow the attorney from either side to make a statement on the record. Felt like nothing more than a flex by the judge. Yeah. And this is something that everyone kept saying because we're still confused. We still don't have clarification. And then retired Judge Carol Erskine said, I love all these opinions, by the way. Today's hearing regarding alleged leaks in the O'Keefe/Reed case left me with more questions than answers. See, we're all feeling the same, guys. If the purpose was to identify the source of leaked information, it is difficult to see just how that objective was advanced when the attorneys were called into court, but not permitted to respond or be heard. Courts have every right and an obligation to protect the integrity of judicial proceedings. But effective investigations typically gather facts, hear from witnesses, and create a record rather than holding a hearing to issue a public reprimand, which risks creating a spectacle. Literally what we saw today. You don't want to pander to social media, sir, but you kind of created a poop storm. As a former trial judge, I would have preferred to see a process focused on discovering what happened rather than a proceeding that appeared to uncover no new information. The ultimate question is simple. What facts did the court learn today that it did not know yesterday? Nothing. Nothing. Absolutely nothing. Now, this is pretty much, by the way, what everyone feels like. From all the different posts I've seen, people that I've spoken to at the hearing, after the hearing. Now, someone brought up a very valid point when it comes to ex parte communications. Oh boy. Oh boy. And I was like, you know what? I think we need to pull up all of the things in regards to ex parte communications. So let's pull it up for a second and we'll go over this. Because things seem a little odd right now. Okay. Coming from mass.gov. Let me make sure you guys are good. Okay. I'm going to scroll down so that we have definitions. Because I'm sure there's some of you that are like, what the heck is an ex parte communication? So I'll read this to you guys. Like I said, from mass.gov. And before I get into this, I am not making any allegations, but I do think it's fair to go over what could have happened because Judge Gildea clearly stated that someone reached out to him. Someone told him something which gave him grave concerns. That's a Beverly Cannoni tweet, not tweet, citation. That's Beverly Cannoni, not Judge Gildea. So what is an ex parte communication? Ex parte communication, per mass.gov, means a communication pertaining to a proceeding that occurs without notice to or participation by all other parties or their representatives between a judge or court personnel acting on behalf of a judge and 1, a party or a party's lawyer, or 2, another person who is not a participant in the proceeding. AKA, what happened here? Someone reached out to Judge Gildea and was like, hey, did you see this? So this is Rule 2.9, and it's all about basically what a judge can and can't do, you know, in essence, when someone reaches out to him about something like this. Okay. There are things a judge can do legally, and then there are things that they can't do. So again, per mass.gov, Rule 2.9, in regards to ex parte communications, it states, Rule 2.9a, a judge shall not initiate, permit, or consider ex parte communications or consider other communications made to the judge outside the presence of the parties or their lawyers concerning a pending or impending matter, except as follows. Except as follows. Number 1, when circumstances require it, ex parte communication for scheduling, administrative, or emergency purposes, which does not address substantive matters, is permitted provided A, the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. And B, the judge makes provision promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. My initial follow-up question when reading this was, is he going to consider their affidavits, all 32 of them, their opportunity to respond? Because I think there would be a valid argument there. It continues. Number 2, a judge may engage in ex parte communications in specialty courts as authorized by law. That doesn't apply here. Number 3, a judge may consult with court personnel whose function is to aid the judge in carrying out the judge's adjudicative, oh God, big words. I need to go back to my Latin. I used to be so good with Latin. Responsibilities, or with other judges, subject to the following. Do you see how there's all these exceptions? A judge shall take all reasonable steps to avoid receiving from court personnel or other judges factual information concerning a case that is not part of the case record. If court personnel or another judge nevertheless brings information about a matter that is outside of the record to the judge's attention, the judge may not base a decision on it without giving the parties notice of that information and an opportunity to respond. Another opportunity to respond, guys. Consultation is permitted between a judge, clerk, magistrate, or other appropriate court personnel, and a judge taking over the same case or session in which the case is pending with regard to information learned from prior proceedings in the case that may assist and maintaining continuity in handling the case. B, when a judge consults with a probation officer. That doesn't apply here. We can skip that. We can also skip C. A judge shall now consult with an appellate judge, obviously. That's a given. We understand that. D, no judge shall consult with another judge. Okay, we got that. That also does not apply right now. Number 4, a judge may, with the consent of the parties, confer separately with the parties and their lawyers in an effort to settle civil matters pending before the judge. Again, that doesn't apply here. Number 5, a judge may initiate, permit, or consider any ex parte communications when authorized by law to do so. Okay. 5B, if a judge inadvertently receives an unauthorized ex parte communication bearing upon the substance of a matter, the judge shall make provision promptly to notify the parties of the substance of the communication. That is what is relevant here, which is exactly what he did. Because it sounds like the moment he found out about this, he immediately ruled, everyone come in. 5C, a judge shall consider only the evidence presented and any adjudicative facts that may properly be judicially noticed and shall not undertake any independent investigation of the facts in a matter. So, a lot of talk online about, well, why didn't the judge do this and why didn't the judge do that? Because per Mass Rule 2.9, should I say 2.9.5C, a lot of numbers. He can't. So what he did technically is proper. He was told, so he brought it before the parties. And then 5D, a judge shall make reasonable efforts, including providing appropriate supervision to ensure that this rule is not violated by court personnel, aka make sure no one else chit-chats or whatnot about it. So, I hope that cleared up just a few of the things that I saw going on in the interwebs, into the webs. Okay. Just to help calm us down a little bit. But you can see consistently it says opportunity to respond, which obviously Seligson and Jackson both were like, hey, which if this was to go up into an appeal, God forbid something more was to happen, if there were sanctions or something goes on, you know, I could see that being a part of the appeal, being like, well, we tried to get him back in and he said no. And then they would go on and on and on about the cost of, you know, the flights and whatnot, and just obviously the nuisance of it. But I realize that may have been a lot of verbiage that a lot of us don't understand. So I very quickly made a phone call and did some Googling so that we can put this in layman's terms, because that's the way I like to understand these things. So a lot of big words. All right, let me make this bigger for everyone. How do I? 100%. Can I do 150? Yes. Yes, queen. Oh, boy. Okay. Because I just know there's going to be many of us that are still confused. Let's really ring this in now. Is 200 too big? Can I get rid of this? Ah, there we go. Okay. So, Massachusetts Rule 2.9 in layman's terms. Layman's terms. Forbids judges from having private off-the-record discussions about a pending case with one side's lawyer or a party without the other side present. This ensures fairness and stops a judge from forming an unfair bias. That is literally everything that everyone is talking about right now. Who reached out to Gildea? Why didn't we find out who? Why didn't we find out the subject matter? Well, we're soon going to learn that he doesn't have to tell you that unless there are sanctions. We'll get into it. So, the core rule, a judge cannot listen to, ask for, or consider information from one party or their lawyer without the other party being notified or involved. Conduct independent research or look up facts about the case outside of the evidence presented in court. So if all Judge Gildea had in front of him, be it a court clerk saw something, someone random on the internet sent him this, another attorney, you want to ask me, it kind of feels like someone on the internet saw it and sent it to certain parties. This is my opinion. Sent it to certain parties. Those parties then sent it to Gildea. That's what I think happened. Just looking at the nature of what's happened in all of the years since January 29, 2022, and how some people have moved, that to me makes the most plausible sense. Obviously, is that big speculation and a big, huge guess? Yes. I'm simply basing this off of how others have acted. And we still don't know. Now, we went into this. Exceptions to this rule. Judges are allowed to speak with one side without the other present in a few specific situations. This did not happen here. Obviously, Judge Gildea pulled everyone in and made sure everyone was present for this. But just baseline, administrative and scheduling, emergencies, court staff and other judges, settlements, problem-solving issues, etc., etc. If there's a violation, if the judge does do some ex parte communications, If a judge accidentally receives an unauthorized private communication about the case, they are required by Rule 2.9 to tell all parties involved and give everyone an opportunity to respond. It keeps going. Opportunity to respond. Opportunity to respond. So then I wanted to get more specific. What if a judge, in this instance, has someone reach out to them in regards to a Twitter post that's regarding, some impounded information, allegedly? If a judge receives notice that an anonymous or public post on X has seemingly leaked impounded court information, they must act immediately to protect the integrity of the legal process. In Massachusetts, impounded or sealed records are strictly restricted from public viewing but remain accessible to the parties and lawyers of record. So you can see why Gildea said, everyone who has been on this case as of June 8th, 2026, i.e. Proctor emergency deposition hearing day, you need to say, tell me via an affidavit who you reached out to, who you told, yada, yada. That's the reason why he did that. So again, you can see he's following the rules. He's doing his job. And then this goes on to say, because a leak means someone with legal access likely violated a court order, a judge would typically execute the following protocol to handle the situation. So this is what he does, or what a judge is supposed to do. Halt the case proceedings. That is what he did. The judge's first priority is to stop further damage. They will often issue an emergency order pausing active discovery, depositions, or filings related to that specific sensitive information until the court can determine the source of the leak. That is what he did. Again, he's following the rules. Number 2, issue a show cause order and mandate sworn statements. That is what he did. The judge will demand that all attorneys and parties involved in the case submit sworn written affidavits under oath. These statements must explicitly state whether they or anyone on their team leaked the information or if they have any knowledge of how the X user obtained it. Lying on these statements constitutes perjury. He's following the rules, guys. Number 3, convene an immediate in-person hearing. Again, this is what he did. The judge will order all counsel of record to attend an emergency in-person hearing. This is done to address the severity of the violation directly and to use the formal gravity of the courtroom to demand answers from the lawyers. So, thus far, he's done everything he's supposed to. Now, here's where it gets a little tricky. This is where the rules / laws of the courts can get a little murky. Because there'll be one part where they say they can do something and then another part where it says they can't. So, he technically cannot reach out to this Twitter user, this X user, right? But what he can do is look at these affidavits and say, what is the rightful source of this information? Well, here's the deal. None of the attorneys leaked anything. So that kind of throws that out the door. Because this in this example, it says the 2:20 p.m. Our actual example is that the filing of the Proctor docs was 2:22. And then he said that this tweet was 2:52, which this example, it says the judge will narrow down the window of who had physical or digital access to the specific file during those 30 minutes, which obviously is only the attorneys. And then this is where once he looks at all of these things, again, not going on Twitter himself, not reaching out to the Twitter user, just based off of what is in front of him. So in this case, it would be the tweet and then the affidavits. That's it. Then this is why he kept saying sanctions, default judgment, yada, yada. Number 5, impose severe sanctions. If the judge determines which party or lawyer leaked the impounded documents, they have the authority to issue heavy penalties, including, this is why he was saying those things, contempt of court, fines or even jail time for defying an explicit court order, evidentiary sanctions, banning the offending side from using certain evidence or dismissing parts of their claims. In this case, it would be no more discovery or deposition of Proctor. That would be an example of a sanction he could put forth. A bar referral, reporting the responsible attorney to the board of bar overseers for unethical conduct, which can lead to suspension or disbarment. Yeah. Financial penalties, ordering the leaking party to pay for the other side's legal fees incurred due to the leak. Literally, if one of the attorneys was to do something, he could do all of these things if he chose to. Now, I asked. Clearly, the judge didn't tell us anything besides what we heard. We got no specifics. So I was asking, doesn't he legally have to tell us? How can you just pull in this emergency hearing and not tell us anything? Well, legally, he doesn't have to. The judge is not legally required to name the person who tips them off, display the Twitter post or X post, or share their exact communications with anyone. With anyone. While the judge must maintain an official record of the proceedings, they have broad discretion over how they handle the initial report of a leak. The judge's obligations regarding disclosure depend on how the information is used and the rules surrounding judicial conduct. The right to protect an informant's identity. If a third party, court staff member, or anonymous tipster calls or emails the judge's chambers to alert them to a leak, the judge is not required to unmask that person. Which, in this case, can be very problematic considering what we have seen in the past. And what it seems like, unfortunately, is that whoever told them this completely blew it out of the water, made a little molehill into a mountain, which then we saw this. So what it seems like, if this is going to become a reoccurring thing, Judge Gildea has to put the reins on the fucking reindeers and stop it. Because what's to say, and some of you have said this in my chat as well as all over the interwebs, what's to stop Michael Proctor or anyone in his family or on his quote-unquote side to now make a fake account and put out his private information? What's stopping them from doing that? Nothing. Because if this is going to be the example that we'll just say trolls have, then what's going to stop them? Nothing's going to stop them at this case. And what are we going to keep doing? Keep spending thousands and thousands of dollars on all of the parties? This is why discretion is so important. Just in daily life, obviously, but especially for a judge. Especially for a judge, and especially when dealing with a case like this where it is so public. And we as a public are so highly interested in it for all of the reasons. Whether you are living in Canton, obvious reasons. Whether you're in the county like me, for obvious reasons. In Massachusetts, or if you're just interested in seeing how this is going to be played out. I'm sure the majority of you care about seeing what's going to be going on with the investigation of John O'Keefe. Maybe it's making sure that there's no more duckery going around. So that really ultimately is the scary thing about this, is that technically the judge doesn't really have to say who sent him anything. This goes on to say, judges frequently receive alerts about rule violations or security threats. They can use the administrative tip to launch an independent inquiry into the attorneys and parties without ever introducing the tipster into evidence. Obviously, there are restrictions. Ex parte communication restrictions. Under standard judicial ethics codes, such as Rule 2.9 that we just went over, judges are strictly forbidden from engaging in substantive, one-sided communications about a case. The exception, a judge is allowed to receive an ex parte communication for administrative or emergency purposes. This would be considered an emergency purpose because the alleged leak was in regards to someone's health information under a sealed document. This obviously includes being alerted that impounded court files are actively leaking online. The disclosure rule, if the communication is purely administrative, like Your Honor, look at this link, your sealed order is in X, it's on X, the judge does not have to disclose it. However, if the tipster provides substantive factual evidence that the judge intends to rely on to punish a party, the judge must notify all parties of the substance of that communication so they have a fair opportunity to respond. Again, we're going to go back to opportunity to respond. We don't know who said it. We don't know what said what. We know nothing. And in my opinion, I don't think any of the parties had an opportunity to respond. When it comes to, and specifically this Twitter/X post, whatever they're referring to, the judge is not required to display the post in open court or attach it to a public order. In fact, if the X post contains highly sensitive impounded information, such as the private medical records or home address of a witness, displaying it or attaching it to a future order would only worsen the leak. Instead, the judge will typically describe the post generally on the record. Example, the court has been made aware of an unauthorized social media post disseminating the contents of the June 8th impoundment order, or handle the specific post under seal. And that's essentially what he did. I think that's almost word for word what he said in his order to get them in for this emergency hearing. Now, here's what the judge must put in the order. If the judge ultimately issues a future order punishing someone for the leak, sanctions, that order must contain specific factual findings. The judge cannot just issue penalties out of nowhere. That order must detail, number one, the evidence of the violation, the specific facts providing a leak occurred. Example, matching timestamps of the court filings to the online leak. And then the basis for the sanction. The proof linking that specific attorney or party to the leak, such as statements made during the emergency hearing or contradictions found in their sworn affidavits. This is where my tentacles started feeling, because what are the O'Keefes trying to claim in regards to Karen Read? That there was a false narrative. That Karen Read was spewing this false narrative, and she's the one that actually ran into John O'Keefe and yada, yada. You guys know the story by now, I'm sure. One of the things that they are inputting in there, and that they're desperately trying to do right now, is integrating Aiden Turtleboy Carney into all of this. So if this has anything to do with the tweet of Turtleboy that we pulled up, someone saw it, sent it to Diller, then Diller sent it to the court, and then the court pulled this emergency hearing. And then when the judge didn't give anyone an opportunity to speak, when Seligson and Jackson asked, hey now, court clerk comes back and says no, and Diller's laughing. Do you see where I'm kind of going with all this in my brain? It's just my speculation. It's just my speculation. Obviously, I have no proof of it. But part of the reason why I go to these hearings is to see everyone's body language and just to see how everyone interacts. The O'Keefes want Aiden Carney so bad into this case. And I haven't gone over those filings yet, but they're really fighting to get him in for all of the things. Which is also part of the reason why they were so anxious or determined to get Karen Read's phones to the point where they, I say, in my opinion, purposely misquoted her. And then purposely changed an exhibit, labeled it as the original exhibit, and tried to pull a fast one on Judge Gildea. Like, you can't, if that is actually what happened in this case, this is just another thing to add to the list. Because do you actually want justice for John O'Keefe? Or do you want revenge? Do you want money? I don't know. I guess that's up for debate. And then this briefly goes on to explain, ultimately, the judge's focus is on what the lawyers did with the court's information, not on the specific mechanics. Sorry, guys, it's been a long day. On the specific mechanics of the digital notification that tipped the court off. So, let me end that. You can see why I wanted to go more into this ex parte communication, because I saw a lot of people asking about things, and I was like, okay, let me look up the mass law just to go over the briefness of it all. But today at this hearing left me obviously with more questions, and it's very frustrating to know all of this was put out there, all this money was spent, and we are left with more questions than we are answers. Do I ever think we're going to find out exactly what this was? Maybe, but I'm not hopeful. I'm not hopeful at all. Like, you've been following this since January 29, 2022. Nothing has been normal about this case. Nothing has been by the book. So many things have been questionable. And it's just like, I was such a young, hopeful little bird walking into the civil cases being like, yay, new judge. Finally, it's not criminal, it's civil, different beast. We'll find out more things. Now here we are. The O'Keefes filed it August or something, like late second half of 2024. So we're almost 2 years into this filing, and it's just gamesmanship, nonsense, tomfoolery. For what? For what? For what? Like I said earlier, Aiden Carney's phone extraction has been put out there. And there's still no messages from Karen Read that state, I did this. No messages from Karen Read that says, oh yeah, I killed John, but. None of that. You can't make this up. I'm behind on all of the things. So let me say hi to some of my folks. Thank you, Frank Manley. I love you, love, love, love you. Thank you for being here. Thank you, Christina, for becoming a member. Thank you, Bob's Mom 69 for gifting 1 membership. Hope you guys are enjoying the emoji. I promise I'll fix the new ones too. I don't know what's going on with YouTube, but they're coming. Thank you, Muser Lena V 999. I am trying so hard to not think that there's some kind of intentional criminal shenanigans, but the judge is making that really hard. I understand. Gildea gave no determination of fact. He cited no sources. I agree, especially those 2 comments where he just said commentator. But then to admonish Rosenberg or Waters or Seligson, whoever did that filing, in regards to pin it on the girl. It's crazy. It's crazy. Technically perjury. I like this. The responses on the docket is going to be fire. We'll see if there's any follow-up. I don't know, guys. Thank you, Belle of the Ball. Frenchie is so cute for becoming a member. Hayden's Ma. Thank you. All aboard the Boozy Cruisy. I love that. Thank you for covering today's hearings of the mutiny of the SS Leaky Plymouth County. Honestly, like, it's not as bad as Norfolk, but this is like, wow. Wow, 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 wow. Oh, Kimberly, thank you for becoming a member. Such a cute German Shepherd. I bet you treat your German Shepherd better than they treated Chloe. Justice for Chloe, too. Never Zengen, thank you for becoming a member. And thank you, Regina, for becoming a member. Emily C., what are you doing? Okay, so here's the thing. Emily says, for 1 month of YouTube Premium, she sends me a super chat. Okay, chat. So I do have YouTube Premium, but I only have it on one of my accounts, and it's my account for my dogs because I don't laugh at me. Speaking about being a good dog owner, when I'm not home, I keep the TV on and I put it on YouTube for like dog YouTube TV, and I don't want the ads to play, so I have YouTube Premium for my dogs. True story. Or they watch Bluey. I wish I was lying, but now I can afford YouTube Premium on this channel. Thanks, Em. No, not Victor Man 2. You guys are just trolling me. I love this. Thank you. Sign up for YouTube Premium. No ads. Okay. I will. Thank you, Melissa. Appreciate you. Thank you for supporting the channel. And technical out 959547 says the judge is a co-defendant with Brian Albert. Oh, I saw this briefly mentioned. The judge is a co-defendant with Brian Albert in a case captioned Raymond C. Green versus Fioriello. I've actually think I've looked up this case before. Originally filed in Mass Superior Court, but removed to federal court November 9th, 2022. I will check. Pacer at work. Thank you. That'd be great. That'd be fantastic. Because I remember seeing that before when I was doing my research, but I don't know why I wasn't too concerned with it. And then I saw you guys talking about that today when I was at the hearing. I did see that. Thank you, Melissa. Aiden posted that at 2:52. The Proctor was in Florida. Yes. We went over that. Yes. Thank you. Cheryl, thank you for becoming a member. Appreciate you. Kitty Cat, thank you for becoming a member. Let me see. I gotta know it. Yes, Leak is his court lady, this new guy today. Oh, I don't know. I really like that court clerk, though. I don't know. I don't get the vibe that she's like sneaky at all like that. That's why I think it was someone sending it to one of the attorneys and then playing the game. That's why. Lori, she says, in my opinion, Judge Gildea is being manipulated like silly putty. The relevant question is by whom? Yeah. Especially for a judge that doesn't like technology, right? that always says all the time that how he's not a fan of technology and how he would just much rather everyone be in person. I agree. I agree. Amanda, thank you for becoming a channel member. Thank you. Thank you. I hope you enjoy the emojis. Craftastical, hey. Install Brave browser blocks YouTube ads and it's free. Oh, that is good looks. Good looks. Thank you. Hopefully it works with what I've got going on here. Hopefully. Okay. Well, chat. All I'm going to say is this. I am very suspicious. I'm questioning a lot of things. And although, like I said, there's not any hardcore evidence, it does seem like someone's doing something. Now, like I said, it makes me question because Aiden's tweet wasn't at 252, and that's why everyone thought it was Grant. But then even Grant's number filing isn't correct. So it's like, this may be one of those things we won't have an answer for a while. Now, can I see this in future filings? Yes. Do I think Karen Reed and the O'Keefes are going to use this in future filings? Yes. And we're going to see which way that boat floats. I can only imagine, because clearly Seligson and Jackson wanted to say something, obviously. And I'll say this right now. They were the only ones, attorney-wise, that were kind of jumping up, wanting to say something. No one else did. Now, I can understand why the bars didn't, because the bars kind of are letting Karen's side take the lead on this, which makes sense in a way, because this really is like the big case against her, and they're kind of just like, kind of seems like they were added onto the case just to get a little more money out of them, which is an interesting play considering how many of the witnesses stated that Karen Reed was not drunk and fine. And then when Proctor said with James Sullivan in his police report interview, they go, yeah, this witness, James Sullivan, who I recognized at this on the C.F. McCarthy surveillance video footage, yeah, he said Karen Reed was toasted. And now James Sullivan is like, oh, yeah, no, I didn't say that. I didn't say that. Not only did I not say that, I also had a meeting with ADA Lally and ADA McLaughlin and Detective Lieutenant Brian Tully, because they were supposed to call me the next day or sometime for trial one. And I specifically told them that I did not say that I said Karen Reed was fine and that she was nice and that she was witty. Duh. If you guys were here for my last live stream, I showed you guys that just how friendly John was with James Sullivan. Grabbed his chin, gave him a little push. Karen was wicked friendly with him, giggling, laughing. I think they were talking about their shoes or something. Like, you could just tell they were having a good time. And that is a witness that was with like direct contact, super close, for over an hour before obviously John and Karen went over to the waterfall. There's just so many shenanigans that it's just like, it's insane. Thank you, Italian Princess. I love your photo for becoming a member. Brenda and Dennis, thank you so much. I appreciate you guys. Great job. Thanks for letting me peep at your notes. You guys, this was wicked funny. So before the hearing started, I was sitting right next to Dennis, and then Brenda was right next to Dennis. And I was like, I saw that Proctor's attorney was right in front of me, and I was like, oh shit. And I went like this to Dennis. I did one of these. And I was like, you know, he goes, no. So I wrote down DeGangi, but I have like the worst chicken scratch handwriting. And he's like, the hell you say? What is that? And so I wrote out Proctor. He goes, oh. And then Brandy was behind me. I was like, Brandy, look. She's like, what? And I was like, in front of me. She's like, no. I'm telling you, like normally these attorneys wouldn't be like seated right in front of us, right? But there was no room. There was no room for them anywhere else. So unfortunately, these two attorneys, DeGangi and then Donovan was with one of the bars, took up spectator seats. Which sucks. It sucks. You can judge me by my handwriting. That's not fair because you have very pretty handwriting and like you can make a lot of money off your handwriting, Emily. That's not fair. Wait, what is this? Shirley Carter says, KP forwarded post to dealer, watch this space. I mean, it wouldn't surprise me, just given the fact where she was saying someone with the phone number ending in 18 leaked anything. And the only reason why, for a moment, like a quick blip in time, where I thought it may have been me before we knew it was like the timing of it all, is because I know where Proctor Mothers worked before, obviously, she retired. That's public information. You can Google that. That's public information. It's literally out in the atmosphere. It's not that hard. So that's why I was like, oh, I wonder if he got a health note from Boston Med Center. But it wasn't me. But she caught me on the counter. It wasn't me. Oh my God. Chat is going crazy. Chat is cracking me up. All right. Gem Girl says, I think the judge is forcing the attorneys in a corner. If he's blaming them now for what they didn't do, if they sign an agreement, then who's to say he doesn't fault them for something again? I know. And he is very much telling them this is the last straw. So if one more thing happens with anyone on any side, he's gonna wacha. You know, he's really gonna like actually like lay down the law. Which again, if there's people playing games behind the scenes, some people are playing a desperate game. That's what it feels like to me. But this is obviously something we've been seeing for some time now. This isn't a new thing. Especially when people are seeing that certain people are hanging out at certain times after certain discovery is given over. Especially people that aren't even on like a deposition list. You know what I mean? Your name's not on a deposition list, but you're going to go hang out with so-and-so right after they get discovery. That's weird. That's suspicious. And I remember at the beginning of all this, I was like, you know what? They're all different parties, right? I don't think the O'Keefes are going to get in the mix with like the McCabe's and Alberts, whatever. Boy, was I wrong. Boy, was I wrong. Inherently wrong. Like, if you didn't think that these guys were all chummy and friendly before, like this shit, just all of these filings and all of the shenanigans that have gone on, it just goes to show if they're not working together, they're definitely in communications. Like, I wouldn't doubt if it was consistent communications, especially when you have people on the interwebs, certain spokespeople that also know things that they shouldn't know. So this is the case where, say it is, as an example, it was the Turtle Boy of it all, right? Let me pull that up again so that you guys can see it. Say it is the tweet. Is it this one? Okay. Say it is this one. Like I said, if a source comes forward and says something like this, it's going to be reported on. Doesn't mean anyone saw anything. Now, who is to say if this was on the flip side where someone else saw something, but they weren't supposed to say anything about it, right? Someone's best friend put something out in the ether. I would just say, be very careful to everyone of what you post, because not only are they now going to be using you as an exhibit, they're also going to try to get someone sanctioned. And guess what? When people are desperate, they do desperate things. So please be careful of what you put on the internet. And I'm also speaking to myself. I am equally giving myself that warning too. All at the same time. Oh, Lordy, Lordy, Lordy. What a day it's been. What a day. Nay, Taylor, hello. Everything comes out eventually. This will too, but so frustrating at the moment. Exactly. Exactly. And honestly, I wish I had more answers for you guys. The only thing that I have is what I saw in the courtroom. And yeah, when I saw Diller laugh like that, I was like, wow, okay. Okay. Huh. 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 No, legit a grippy sock vacation. Legit. Legit. It's just like him, Proctor being his house being sold. Obviously, that's public record. You know what I mean? Anyways. What did Kyle Sharkey say? Kyle, you're being dragged into this now too. Kyle Sharkey, one of my favorite. We'll call you the keeper of the records. Poster of the records? Public records, not private records. Judge Gildea or anyone listening to this, public docketed records. Kyle Sharkey. Boozy, they will know all about the goats and penguins soon enough. I swear to God. I swear to God. If they put up any posts from Grant that says this is the Queen of France and she's made out of bread, I will lose my cookies. I will actually lose my cookies. For those of you that are confused about that, don't worry. Don't worry. Don't worry about it. Our friend Grant's called me the Queen of France. That's fine. You did? You did? You guys did? Hold on. I still have it up. Let me see. You saw him laugh too? I'm going to pull this up now. Just to, I want to double check. Okay. Judge Gildea's emergency hearing. If this shows an ad right away, I'm going to laugh my butt off. Oh God, it's still on an ad. Hang on a second. Wait, what happened to it? Oh Lord. Hang on a second, chat. Let me figure this out. This is when I should do a fervent song. That's the life of a Proctor defender. Okay, cancel that. Replay. I want to see if we can see them laugh. What are you guys saying? Everyone's talking about the goats now. I'm dying. Which, by the way, I know the camera's moving. I'm so sorry. I did order a special connector for my mouse, and it is not in yet. So we'll have to come back to that once it's back. Okay, I want to see. I muted it just because. Let me see. Okay, so this is the end of the hearing. Seligson and Jackson are about to lean forward, but then the camera pans. And then the camera's done. Oh, yeah, no, you guys did not see what I saw. Oh, no. No, you didn't see it. You can see Attorney Hassett right there at the bottom. And then Wolk, Little, I think that's Mason. Yeah, no, you guys didn't see what I saw. Oh, no. Oh, no. I'm not. You're going to have to take my word for it. It was a shitting grin. Nah, like a type thing. Oh, in the beginning. Yeah, but a bunch of the attorneys were laughing in the beginning too. Queen of France or Queen of Rants? You guys haven't seen my rants on here yet. Just wait. There will come a time when you will see one of my rants again. I'm a little more subdued right now. I'm a little more chill, a little more relaxed, because this could be worse. It could have been worse. He could have made an assumption and sanctioned whoever he wanted to sanction. Instead, he just threatened everyone with everything. Yeah, it was off cam. And I remember watching the camera guy, and he just like panned it right on up. I was like, why is he immediately pulling away? Like, shouldn't you want to see what everyone's doing afterwards? Because usually what the cameraman does is that they usually go over to the parties, right? So usually it's always Karen Reed that's there. So they'll like scan over to Karen, or if any of like the House defendants, Ham plaintiffs, the O'Keefes, they'll always pan over to them. But this guy was just kind of like, no, I'm gonna, not worry about it. I don't know, guys. I don't know. I rant when I need chocolate. Same. So, like I said, I hope I could have provide a little bit more insight. It was very obvious. Everyone was kind of up in arms. All of the parties. Media was like, what the hell's going on? All of us spectators were like, what the hell's going on? Not what we were expecting. Totally different from the last emergency hearing, which was when Proctor tried to pull out of the deposition. I wish I could say I was super surprised and super shocked. Nope. Not horrified. Not in the least bit. But that's all I got for today. I just wanted to briefly do the hearing. I've been on 2.5 now, so 2.5 hours. It's been a doozy. It's been a day. If you guys comments, questions, concerns, please feel free to leave them in the comment box below. I'm working on fixing some more things around here, so I appreciate you all for being patient with me. Truly, like, it's a lot. You don't realize how much goes on behind the scenes until you actually do it, and it's like, oh yeah. But yeah, guys, like I always tell you, you all matter. Trust me, it doesn't matter if you are a creator, a law tuber, or you're just a simple viewer that doesn't comment. It doesn't matter. Whatever you do for the case for Norfolk County, Massachusetts, even if you just are here because you're bored and there's nothing else to watch, I do appreciate you all. Like I said, it doesn't go unnoticed, especially what you all have done for me. And yes, I said for me. Truly, I'm always going to be grateful. And I hope you all have a beautiful time this weekend if you celebrate. Hope you all have a day off or multiple days off. If you have kids, I hope you can get away from them for a little bit. And enjoy. Be safe. It's supposed to be very hot. Please be safe. Drink your water. Fun fact of the day. In order for your body to function, you need half of your body weight of ounces in water each day. Here's the problem. If you drink coffee or alcohol or things that are like, not good for you, and you drink even more water. So please be careful in the heat, because it seems like everywhere is hot. The whole world is hot. So isn't the courtroom. Anyways, guys, please make sure you do the likes, the comments, all the things. Come back, hype. I don't know what that means, but I'm being told I need to say that. And I'll catch you on the next one. Couple of days. There's going to be more things we need to talk about. There's been a lot of filings that I haven't gone over yet. So please make sure, again, like I said, like this channel, like this things, do all the things. And I'll catch you guys on the next one. Please be safe. Like I said, I love you all so much, and take care of yourself. Bye, guys.